the defense team is ready. Whether or not the petition or whatever resolution or action that the Supreme Court would have on the petition that we filed yesterday, the defense team is ready.
Yan ang binigyang diin ni Attorney Sheila Sison, isa sa mga legal counsel ni Vice President Sara Duterte sa kanyang impeachment case. Sinabi yan ng abogado sa isang forum ng University of the Philippines College of Law. Matatanda ang naghain si Vice President Duterte ng petition for certiorari and prohibition sa Korte Suprema para questionin ang proseso ng impeachment sa Kamara at pigilan ang Senado sa pagsasagawa ng paglilitis. Naniniwala ang pangalawang Pangulo na gagampanan ng Korte Suprema ang tungkulin nitong ipatupad ang batas at pangalagaan ang demokratikong prinsipyo. Kasama sa kanyang legal team ang mga abogado mula sa Fortune, Narvasa and Salazar Law, pati na rin ang kanyang ama na si dating Pangulong Rodrigo Duterte at ang kanyang father-in-law na si Attorney Lucas Carpio Jr. Sa kaparehong forum ay nandoon din si San Juan City Representative Isabel Maria Zamora na kabilang naman sa mga prosecutor ng impeachment case. Ipinaliwanag ni Zamora kung bakit tinanggap niya ang alok na maging bahagi ng prosekusyon.
First, I was asked if I wanted to do something for the country. Second, as Vice Chairperson and an active member of the Committee on Justice in Congress, I believe that it is my duty to see the complaint through. Third, I was told that they needed someone who was matalino, mabait at maganda.
Sa panig naman ni Attorney Sison, binigyang diin niya kung gaano kabigat ang impeachment process, isang punto na matagal nang binanggit ng yumaong Senadora Miriam Defensor Santiago.
According to the late Senator, impeachment is a dreadful process. It inflicts a deep wound on the country. I agree. It is a stunning penalty. It is a dreadful process. It ruins a life.
Giit pa ni Sison, hindi pa man nagsisimula ang formal na proseso ng impeachment ay may mga buhay nang naapektuhan dahil sa matinding batikos at negatibong public opinion.
In fact, I can even go one step further and state the reality that long before the impeachment process has begun, a life is already ruined by accusations made public and with the amount of heavy criticisms made for public consumption without the benefit yet of a trial.
Dean Darlene Barberabe, Senator Robin Padilla, former Senate President Franklin Drilon, Retired Associate Justice Conchita Carpio Morales, Commissioner Rene Sarmiento, my professors in the UP College of Law, non-teaching staff, guests, students, good afternoon. I am Isabel Zamora from Batch 2008, Block C, and it is my honor to once again be in the hallowed halls of the University of the Philippines College of Law, albeit in a different and fancier location. Never in my life did I think that I would speak in front of my professors or be chosen as a prosecutor in an impeachment case, as I always regarded myself as a simple girl. The role of being a prosecutor was offered to me on our last week of sessions, and I accepted the offer for several reasons. First, I was asked if I wanted to do something for the country. Second, as Vice Chairperson and an active member of the Committee on Justice in Congress, I believe that it is my duty to see the complaint through. Third, I was told that they needed someone who was matalino, mabait at maganda. So I said, hindi naman. I initially had doubts after I was nominated, as I thought I was not a great trial lawyer. But sabi nga, para ito sa bayan. I was tasked by my friends and Congress colleagues from UP Law and UP to wear something maroon on the first day and to raise the flag of UP high. I am both excited and anxious about my new task. I brought out my highlighters and Post-its the following day and started reading. It brings back tons of memories from law school. I take this opportunity to mention a few aspects about the case. The complaint was culmination of a meticulous, transparent, and televised fact-finding effort of the House of Representatives. Certain matters, in fact, arose during the budget deliberations in 2023. Copies of the complaint were circulated to the members, and in fact, on the first circulation, I was already able to read the articles. Some members voiced their opinions on the matter. 215 members signed the complaint. The House prosecution will show that Vice President Duterte, since her assumption to office, has repeatedly, egregiously, and grossly violated her solemn oath and pursued actions that amount to culpable violations of the Constitution, flagrant betrayals of public trust, graft and corruption, and other high crimes. In particular, Vice President Duterte committed the following. She contracted an assassin and plotted to murder the President, the First Lady, and the Speaker of the House. She misused and malversed confidential funds appropriated for the office of the Vice President and the Department of Education. She disbursed or gave away monies amounting to graft and corruption, among others. The House prosecution has been meeting and preparing for trial to commence, as we believe that there is no other interpretation to the provision in the Constitution that trial shall forthwith proceed. I have so far been able to gather a lot of know-how, insights, and intelligence from the other panelists today and my professors today. I am extremely grateful for this opportunity, and I thank Dean Berberabe and all of you for bringing me back to the university that I love dearly. Thank you.
Thank you, Congresswoman Zamora. I understand that Attorney Sison also has a few remarks.
Dean Darlene Marie Berberabe, the Senator Robin Padilla, retired Supreme Court Associate Justice Honorable Antonio T. Carpio, former Senate President Franklin M. Drilon, retired Associate Justice Honorable Conchita Carpio Morales, Honorable Rene V. Sarmiento, Attorney Ramon Esguerra, Associate Professor Gwen Grecia de Vera, Assistant Professor Theodore Te, Congresswoman Isabel Maria J. Zamora, Attorney Fina Bernadette A. de la Cuesta Tantuico, and my senior partner in Fortune Nervasa and Salazar, Attorney Gregorio Y. Nervasa II. Ladies and gentlemen, good afternoon. I would like to thank the UP College of Law, Justice George A. Malco Memorial Foundation, Inc., in partnership with the Philippine Law Journal, for the invitation to join this forum today that aims to encourage meaningful conversations on the emerging issues in impeachment, especially since we come to this forum as counsel for the Vice President, whom we know is now the subject of impeachment efforts. We appreciate the opportunity given to partake in today's discussion and listen to perspectives from which we could all draw some insights that hopefully would enrich the dialogue and our understanding, as well as of the public, about the impeachment process. The other night, I was reading a keynote speech that was delivered by the late good Senator Miriam Defensor Santiago in 2012. or 13 years ago. This was delivered before an annual convention of a Society of Doctors and Physicians. Now, in that speech, she cited the fundamental book on the topic of impeachment, authored by Professor Charles Black, Jr. of Yale University, and summarized as well the thoughts that the latter had on the matter. According to the late senator, impeachment is a dreadful process. It inflicts a deep wound on the country. Now, Professor Black, in his disposition in that book, described impeachment in this way, and I quote, "Removal by conviction on impeachment is a stunning penalty, the ruin of a life. Even more important, it unseats a person whom the people have deliberately chosen for that office." I understand, of course, that many who had come to this forum may probably already had formed their own opinions. This is but natural in a democratic country that values and encourages free speech. But I agree, it is a stunning penalty. It is a dreadful process. It ruins a life. In fact, I can even go one step further and state the reality that long before the impeachment process has begun, a life is already ruined by accusations made public and with the amount of heavy criticisms made for public consumption without the benefit yet of a trial. And perhaps that is the significance of having this forum today, in that we are reminded that despite our personal convictions and or opinions on issues surrounding the current impeachment efforts against the Vice President, impeachment remains a serious constitutional mechanism that must be done only in the manner permitted by no less than our Constitution and the standards it had set therefore, in accordance with principles of fair play and the rule of law. I am hopeful that this forum would contribute to elevating the discussion among our people. Again, good afternoon at maraming salamat po.
Thank you very much, Attorney Sison. Congresswoman Zamora and Attorney Sison, to go to the questions that we raised over the weekend and which she gave you ahead of time, we would like to ask, how do past impeachments or past impeachment trials inform your preparation for this upcoming trial, if you could answer it? Congresswoman Zamora.
Professor Tomasa, so as I earlier mentioned, the prosecution has already been reviewing and studying and preparing for the trial. So in fact, we studied the past impeachment cases. We have a list, tables of all impeachment cases filed before the Committee on Justice, or those that went straight to plenary. And I know two particular impeachment cases. First, in the in President Estrada's impeachment, we know that there was an issue of the second envelope. I was not yet a law student at that time, but from my understanding, there was a need. They wanted to open it, and that was the reason why the senators walked out, because of that second envelope. So what we thought was that there's a need to sift through our evidence. We should check all the pieces of evidence that we have and see whether these are really important. Second, learning from the era of impeachment was that public support is very important, as this is a political exercise. It is political legal for some, but the influence of the public is very important, and we should muster the public support in this case. Second, that I noted was in the Corona impeachment back in 2012. If I'm not mistaken, several articles were withdrawn. I believe it was 5 articles, and that tells us on the prosecution side that we should in fact be ready with our articles. We should be able to defend these articles and have evidence for each. We should prepare so that we won't be berated by Senate, especially the lawyer, senator, judges. As in fact, some were berated. Some of the members of the prosecution were in fact berated by Senator Miriam, if I'm not mistaken. I believe it was during that impeachment also that they were berated on rules of evidence, and this tells us that we need to have a cohesive prosecution. We have to have a firm stand and complete evidence for all of the articles.
Thank you, Congresswoman Zamora. Attorney Sison, would you like to weigh in on this question?
Yes. Earlier, I was actually asking my senior partner, Attorney Audrey Narvasa, about this question. And I told him it should be you who should answer this question because you're older than me. And he was part of the era Estrada impeachment defense team. And I think I was still just being born at the time. So really, if there's anyone who can answer this question in this room, that would be Attorney Audrey Narvasa. But all right, kidding aside, 2 things come to mind when it comes to past impeachment trials and how it would help us in the upcoming trial. But let me just point out before I answer this question, because the premise of this question is there will be a trial. And I think I have to be candid enough to disclose that yesterday the defense filed a petition challenging the validity of the 4th impeachment complaint that was referred by the House to the Senate. But let's assume that trial would indeed proceed. How do these past impeachment trials inform the defense team? In response to the question, Attorney Audrey shared that during their time, which was 25 years ago, anything goes. There were a lot of things that happened outside the impeachment court, and I suppose that is because impeachment process really is a unique intersection of law and politics. And this is something that we also anticipate could happen and would happen this time. Because even now, prior to the Senate constituting itself into an impeachment court, we could already hear a lot of people wanting to put in their 2 cents on the matters and on all incidents, on all issues that come out of this whole impeachment process. In fact, even prior to the filing of the 4th impeachment complaint, we could already see and hear a lot of people chiming in on the things that were discussed at the hearings that were conducted by the House. And of course, this contributed to our people developing some opinions. Probably most of them are strong opinions. And so this is something that the defense would also have to prepare. Well, this is, not without, it goes without saying that we are prepared just by being the lawyers of the Vice President, that we would be under heavy scrutiny by the public. And so this is also something that we really need to prepare. But apart from the preliminaries, just like what Congresswoman Zamora said, the defense team is ready. Whether or not the petition or whatever resolution or action that the Supreme Court would have on the petition that we filed yesterday, the defense team is ready. Now, on the details of the preparation that we had done, I think that it would be prudent on my part not to disclose yet the level of preparation or the things that we are doing at the moment in order to be able to come to the trial well prepared.
I understand the limit, and we're very grateful that you actually agreed to our invitation to join the conversation this afternoon.
Yes, that's as I advised you when you extended the invitation to us. I really cannot disclose or discuss any matters pertaining to evidence, strategies, or defense. That's why there was a question that I actually requested you to take off the list, because it's really something that I cannot talk about.
Which we also removed the equivalent question for the prosecution.
Yes, I understand.
So, but I hope the next question isn't, you'd be willing and free to answer regarding questions about the Senate rules. And unfortunately, despite impeachment being political, and that's something we learned from the first panel, inevitably, the proceeding itself is likely to be couched in law. And, it will involve statutes, it will involve the Constitution itself, and the rules of the Senate. So, having looked into the current Senate rules for impeachment, is there anything coming from the conversation the earlier panel or throughout your preparations which you think or you would want the Senate to consider or reconsider as part of the impeachment process?
Exactly. There's actually one. Proceeding from the discussion earlier and from what has been discussed even in media, there is Section 11, if I'm not mistaken, that an adjournment of the Senate sitting as a trial court shall not operate as an adjournment of the Senate as a legislative body. So, in my humble opinion, I think that the reverse should actually be stated as well, so as to remove all of these issues on whether we can proceed with trial.
Thank you, Congresswoman Zamora. Desisyon, would you have anything to suggest?
I actually prepared 2 items in respect of this question, but based from the discussion that we had with our legal experts in the first panel, it would seem that the general track or agreement, at least, is that there could be no standard of proof or the degree of proof by which impeachment cases can be decided by the Senate. And whether it is clear and convincing, substantial evidence, mere preponderance of evidence, or beyond reasonable doubt, proof beyond reasonable doubt. I think that is something that we could agree is not included in the rules just as yet. And I would understand why. It's because if you read the rules on impeachment, really the senators, judges would mostly be deciding on the entire matter of the impeachment, as well as the incidents or the mini incidents that will crop up in that trial, based only on their conscience and based on the oath that they will be administered, that they would promise that they will do impartial justice. So one of the items that I wanted put, if I have my way, would be, a certain standard by which the impeachment process would be decided. And the reason for this is not because I want a higher quantum of proof. Of course, I want a higher quantum of proof. I'm a defense counsel. If it's going to be, if I have my way now, Senator Padilla, would you, consider putting in a standard of proof that, it's proof beyond reasonable doubt, or probably much, if there's any higher creature than that degree of proof. But the reason why I want some standard put in the rules is because, isn't it also in the public interest that we have some uniform standard by which the senators, judges would be able to consider every incident and motions that would come up in the trial? Because then it would lend not a semblance of legitimacy, but it would at least deflect questions on whether the proceedings that were conducted by the Senate and the rulings that the senator judges made were legitimate or at least fair. The second, of course, is just, on the more practical considerations. Perhaps it's also for the benefit of the prosecution team or Congressman Zamora. Perhaps both parties, if trial would indeed happen, perhaps a set timeline of everything, the submissions of motions, the examinations of witnesses, just so both parties or clear expectations are set for both parties. I guess this is also because largely this would be a public affair, and by public affair I mean everyone will want to watch the proceedings and see how it's going.
Attorney Desisyon, if I can ask a follow-up question on that, does it mean that the defense and Congressman Zamora, the prosecution would, for example, be open to, let's say, a pre-trial proceeding before the Senate, or where for the non-lawyers, where basically the parties present the witnesses that they will present, the fixed list of the evidence that will be presented? And I think that the Corona impeachment has something like that at the very least, or even almost pre-trial discovery, as what the Nixon versus United States Senate did. If only you're comfortable with answering that question.
This is for me.
Yes.
I think the general consensus is to make the trial conform with the standards rules or fair rules, but also for the trial to proceed in an efficient manner. That's where I'm coming from. If the rules would be able, or the Senate would, for example, be able to come up with something definite, something that both the prosecution and the defense would have to pay in respect of the proceedings that would be conducted in the Senate, I think that would be in keeping with giving the entire process not expediency, but some order that no one would be able to question the legitimacy of the entire process, or even, the separate votings that the senators, judges would eventually make on some issues.
Congresswoman Zamora, your thoughts?
Actually, I agree with her statement that there should be some order to the proceedings. Going back to the standard, to the requisite standard that we need to convict. I agree with my professor Te that it should be something that will convince a senator or even a layperson to remove the official, and it should be convincing enough that it carries a consequence. Then the consequence that he or she will be further disqualified from having future office. I remember also the standard mentioned by Bernas on his impeachment primer. Since it is a political exercise, the standard is his gut feel. So it is the gut feel of the senators that is required. And while I know that isn't a lot, and we cannot quantify that, it goes back to the process being a political exercise.
Thank you, Congresswoman Zamora. We do have just one last prepared question before I think we can go to an open forum, and I hope the first panelists can join us again for that. The last question is, should the public be able to influence the trial as a political exercise? And if so, to what extent? And for the non-lawyers, those who are outside of law, generally, if it were a court proceeding, and to a certain extent even an administrative proceeding, we really don't want the public to weigh in on how a judge or an administrative judge would rule on a particular case or complaint. But I think both speakers recognize, the earlier panel recognizes, that impeachment isn't really a strictly legal proceeding. It's a mix, at the very least, of a legal and a political proceeding. So in your opinion, right, should the public be able to influence the trial as a political exercise? Vice President Duterte is a popular figure, as much as the perceived people who are against her also have their own base of support. So your thoughts, please.
I think it shouldn't be a question whether the public should be able to discuss or talk about the impeachment process, but the question really is whether or should the public be able to influence, so meaning there's some level of exertion of influence. By how? Probably by information that are circulated in social media, the mainstream media, etc., etc. In Professor Black's opinion, what the public should do in cases of impeachment really is to do what he refers to as vigilant waiting. And I agree to some extent that even as we allow the public to speak on matters that affect, their interest or the accountability of our public officers on some alleged and purported wrongdoings, I believe that it would be better that there has to be some balance. Now, whether the public should be able to influence how eventually the senators would have to decide on the impeachment case, I think that's another matter. But one other thing, and to my mind this is what's more important, that this forum, our fellow lawyers, and of course our law students would probably be able to to help in terms of elevating the quality of public discussion. And this is because it's important that even as we encourage our people to speak on matters of national concern, we should be able to help them sift through and navigate through the facts and be able to separate facts from fiction, and to be able to assess evidence-based assertions over mere propaganda or rhetoric or grandstanding.
Thank you, Attorney Season. Congresswoman Zamora.
I think what Attorney Season said was actually very good. In fact, that we should really elevate the discourse, the level of discourse as regards impeachment. I guess for both sides, there are many things that are circulating, and we have to keep it to what we have as facts only. I think being a political exercise, of course, the public will always influence. In fact, if the question is, should the public influence? Yes, but maybe to a certain extent, maybe we should limit it to what is within the bounds of law, what is proper, maybe what is fair, and I think that we should allow both sides to also be able to present their evidence properly, completely in trial, and I know that for the senator judges, there will always be political considerations, even if we have our evidence. Both sides would have their evidence. The political considerations will always come into play. So that's my take on that.
Thank you very much. A round of applause for our panelists.